All right, we're here with part 2 from chapter 5 on dispute resolution, and we've worked through the state court system and the federal court system. We've talked generally about trial courts and appeal courts and what happens in each of those types of courts, and all the various forms and types of dispute resolution. So that was all in part 1, and here in part 2 we're going to look at how decisions are made by the U.S. Supreme Court, the voting process essentially of how that's done. We're going to talk about the differences between state and federal jurisdiction, what's involved in that for state courts and federal courts, and then we're going to broadly talk about the process of civil procedure, and from the point of filing a complaint all the way up to going to trial when we haven't been able to resolve a matter through any of the methods of alternative dispute resolution. So often it's kind of interesting, if you listen, people will say, I'm taking my case all the way to the U.S. Supreme Court. Well, that's fine, but as I mentioned at the end of the last PowerPoint, there's only a very small percentage of cases are required. Is it required for the U.S. Supreme Court to hear? You have a state that sues another state. You have a U.S. ambassador that's involved in something, or the president is involved in a case or something like that. Those cases can originate in the U.S. Supreme Court. They don't have to go through the normal process, and the Supreme Court has no option but to take them. The rest of the cases that are presented to the U.S. Supreme Court, it's optional as to whether the Supreme Court actually takes them on or not. So not everybody can get there automatically. I think, trying to recall again, I think the average number of cases that are sent to the U.S. Supreme Court each year to be heard is somewhere in the order of about 1,200 to 1,400, and how many it actually hears is approximately about 150 in the course of a year. So we're talking less than 10%, or around 10% of all the cases that are presented to the U.S. Supreme Court does it even make a decision to hear. So how you do this with your case, you've lost at the state Supreme Court level, highest court in your state, or if you've been through the federal court system instead, you've lost maybe at the trial court. You've certainly lost at the Court of Appeals, and now the Circuit Court of Appeals. From the Circuit Court of Appeals, you're filing your case to get to the U.S. Supreme Court. And so the U.S. Supreme Court, what you do is you file what's called a petition of certiorari. You're asking for the U.S. Supreme Court to certify your case and issue what's called a writ of certiorari. So if they do present, say your case can be heard in the U.S. Supreme Court, it's a very formal thing. They provide this writ of certiorari. It's stamped with the old wax seal, like the old formal thing that you used to see with the old English common law courts. They do, and it's a formal writ that you receive. This document you see on the right here, actually, it's interesting. If you ever get a chance, watch and you can read the book or watch the movie. I think Henry Fonda starred in the movie. It's an old black and white from the 50s or so, 60s. I'm sorry, because this case was decided in 1961. It involved Clarence Gideon, and the book is called Gideon's Bible, and I believe the movie was the same, or Gideon's Trumpet, excuse me, and it's interesting because you had a man who was accused of murder in the state of Florida, and he kept saying he was innocent all along. He didn't have an attorney and actually studied in the law library, or the library in the prison he was in, and actually wrote his own appeal. And here's the appeal that was presented that he did, and actually in the end his case was overturned and he won. So can it be done? Yes. In this case it's pretty rare, but it does happen. Interesting situation. So how does the U.S. Supreme Court decide their cases? They listen. Each side presents that they provide a brief that is establishing all the legal precedent that they believe supports their particular side and why the other side is incorrect. why either the lower court applied applied the law correctly or incorrectly. They supply that brief to the court, and then they have to have oral arguments. So there are no witnesses again. Judges are all present, usually. All 9 are present for the U.S. Supreme Court. And then you have the lawyers on each side that present their case. They have a timed argument to present, and as they present, they're asked questions as they go through their presentation. The judges have all read the briefs. The judges have had clerks to help them look up lots of case law that is relevant to the case at hand. And then there's oral argument that's had, and at the end of all that, the judges go back in chambers and they essentially vote and draft opinions on the basis of who they think should win the case. So it's actually voting in the sense of they're in favor or opposed to whoever the appellant is in their argument, and if they all agree, it's a unanimous decision. You have a 9-0 vote. It may be that it's a majority decision. There are 4 or 3 or 2 or 1 that disagree with what the majority says, but all you need is a 5-4 decision on your side, and you win. Any of those majority decisions, that's is a good thing. Sometimes you have a 5-4 decision. It's very close, and it's called a plurality decision because not only is it close, so many people, even in the 5 who agree on the result, have different views on the law of how they got to that result, that later on this case isn't really good to cite as precedent for you if you had a case that came after, say, Clarence Gideon, if there was a 5-4 decision and there's multiple, a plural number of decisions, opinions written by the judges on the 5 side, it would make it it'd be so muddy as to what the real law is. So a plurality decision isn't necessarily good. It could be a 5-4 decision if there was one opinion drafted and all 5 agreed with that opinion on the 5 side on a 5-4 decision. Then that's a good case to cite later on. If you were bringing your case to the Supreme Court, you could say, well, in the matter of Smith versus Jones, this court ruled 5-4, but it was unanimous of the 5 as to their opinion as to how the law should be determined. That's a better decision than a plurality decision where you have multiple views as to how you arrived at that majority ruling. Sometimes you might have a tie decision, and that seems odd, but because there's 9 judges. But in the U.S. Supreme Court, it's occasionally it happens where one of those justices has would have a bias. Maybe they have stock in a company that the case is about. Maybe they know one of the parties or are somehow connected to one of the parties involved in the case. So one of the judges will step out. They say they recuse, R-E-C-U-S-E. They recuse themselves from hearing the decision or making the decision in the case. And in some cases it might be that the justice is sick. Chief Justice Rehnquist had thyroid cancer, I believe, and was out for quite a while, and he's passed away not long ago, but for many cases he was not available to even make the decision. So you had 8 justices, and if they had a 4-4 tie, then that's what they had. In any cases where there's a tie decision in the U.S. Supreme Court, whether it's because some judge was out because of a conflict of interest or health reasons or any other reason, if it's a 4-4 tie decision, the decision that stands is what came out of the circuit court below. So whatever the Court of Appeals decision for that circuit. So we're in the 9th Circuit. If we brought our case originally in Washington State District Court, we lost. We filed our appeal to the U.S. Court of Appeals for the 9th Circuit in San Francisco. If we filed our case to the U.S. Supreme Court, and unfortunately there were 8 justices present, 1 sat out. If we ended up with a 4-4 tie, whatever the result that came out of the 9th Circuit Court of Appeals would be what we have to live with. That's the final decision. Okay. Whenever you have you have a unanimous decision, it's obvious that it's going to happen this way. But if you have majority decisions and even concurring decision, you have, plurality decision, you have, at the end of any case, there's a U.S. Supreme Court decision that's had, what you have is an opinion that's drafted. It might be that one of the judges drafts the opinion, or they might have someone else, one of the other justices, help them draft the opinion. But there's one opinion, and maybe all 9 justices sign their names to it. If there's a majority decision and it's a 6-3 or 7-2, 8-1, whatever decision, and the majority agree with the result, it might be they differ on the law a little bit. So you might have a concurring opinion that's drafted by one of the majority justices that says, yes, I agree with the majority, but I also think da-da-da-da-da, and they say something like that. Okay, that's called a concurring opinion. I concur or agree with this justice on this case, or these justices on this case, but I have a little bit different legal reasoning as to how we get to the result that they got to. Sometimes you're going to have a dissenting opinion, and anytime you see where you have the majority side, so you have 5-4-6-3 and all that, whatever the minority side of the ruling is, the 4 or the 3 or the 2 or the 1, they might write a dissenting opinion, and they say essentially that the majority in this case is totally wrong because of, and then they spell out all the law that they believe why. So they're always on the losing side of the case, but they're drafting a dissenting opinion which is saying what they believe the law to be. Dissenting opinions get read by all sorts of people who are trying to change the law along the way. And so later on, you can look for a case that might have been a very close decision, but you look at the dissenting opinion of a justice who you believe really had the correct interpretation of the law, and then you're going to argue that later on in your case as you bring your case forward. So these opinions get drafted, and this is the voting process, and that's how the U.S. Supreme Court essentially works. Okay. So now we get to the issue of jurisdiction, and jurisdiction is just a fancy word for power, ultimately. And the question is, does this court that we're talking about have the power to hear this case? So we're looking at federal courts first, and federal courts may hear the following types of cases. Cases that involve a federal question. So spelled out in the Constitution, it says that these are cases that arise under the U.S. Constitution, any treaties that the United States has ratified, so ones that the President has signed, but the Senate has also agreed when we are bound to those treaties, so that can be something, a federal statute or a federal regulation. Any case that involves that, so if you have a constitutional case that involves a Fourth Amendment, Eighth Amendment, Fifth Amendment, whatever, NAFTA, the North American Free Trade Agreement, or any federal statute, your case technically could be brought in federal court. You might also have diversity of citizenship cases, and so that's another opportunity for you to get into federal court. And so this would be a case that's between you and someone from the state of Oregon, let's say. So you're driving on I-5, and there's a major accident. You're from Washington State, the person who hits you is from Oregon. That case could technically be brought in federal court, depending on the dollar value of your damages, which we'll get to in a second. But the diversity of citizenship is one way you could get to federal court, or federal question cases. And the other way could be in diversity of citizenship could be somebody who's a citizen of Washington, and instead of getting hit by someone on I-5 who's from Oregon, you get hit from someone who's from Sweden, let's say. And in that case, the case could go to federal court as well. Okay. The dollar value, and I have to double check this, the most recent that I had was the dollar value of your case had to be at least $75,000. So if your case was a $20,000 case, you're going to end up in state court, even if it was a federal question or a diversity of citizenship case. If the controversy value is not likely to exceed $75,000, then it's unlikely that you are going to get into federal court. Okay, it's spelled out. And I had to double check the value of that, but I believe it's $75,000 is still the current value. State courts, on the other hand, so that's federal courts. State courts can hear some of the same cases. So any of those cases that were, let me back up for a second. Any of those cases that were federal question cases or diversity of citizenship cases, you could choose, instead of going to federal court, you could go to state court. As long as you're, even if your dollar value was over $75,000, you may choose to go to state court instead. So state courts can hear those same type of cases. They just can't hear any of these ABC variety, and that's spelled out very specifically that they're federal cases, and that is the ABC are these cases. A is antitrust cases. So a case that's involving, say, a few years back, Microsoft was accused with its operating system to be having a monopoly on all new computers that came out when Windows was the main product that was an operating system on computers. Microsoft was sued for antitrust violations. So having a monopoly, impact of a monopoly in the marketplace. So that's an antitrust case. That cannot be heard by a state court. It's an antitrust case. It must go to federal court, period. B stands for bankruptcy cases. Bankruptcy courts cases, if your business is going to go out of business or you have trouble paying your creditors and you're seeking bankruptcy protection, that has to go to federal bankruptcy court, not state court. The C cases are copyright, and copyright also and patent cases have to go to federal court. Trademark is the same way, any of those intellectual property cases. So the C standing for copyright. If you had music that you believe somebody stole your copyright rights to, they copied your music, then you would bring it in federal court. You would not bring that in state court. So state court has no jurisdiction over ABC cases, right? Otherwise, what's called concurrent jurisdiction is at the same time there is jurisdiction potentially in either of the two courts. It could be federal court or state court. So I say state courts have jurisdiction over diversity of citizenship cases and even federal question cases. So it's okay to bring your case in state court if you would prefer. That's the concurrent jurisdiction means simultaneous jurisdiction. There is jurisdiction power of either the federal court or the state court to hear those cases. Your case is over $75,000 in value. It involves two different citizens, and it involves a federal question issue. It happens on I-5. It's a federally funded interstate highway that could be brought in federal court, or you could choose to bring it in state court. You couldn't bring it both at the same time, but both courts technically have jurisdiction. So in that case, you could bring it in state court. So it's okay with concurrent jurisdiction cases. And as long as there's no federal exclusive jurisdiction, those ABCs that I've already mentioned. Okay. So another issue that comes up here, it really happens in both state and federal courts, is this idea of standing. And essentially the plaintiff, the party who's bringing their case, has to actually have a stake in the outcome. So I couldn't bring a lawsuit on behalf of my sister. The court's going to say, do you have a right to be standing in this courtroom? And I'm like, well, I care about my sister. Well, that's not enough. If my sister was the one who was harmed in the case, she's the one who has to bring the lawsuit. Now, if I had some legal requirement or legal guardian, she was my guardian because she had some, she was incapacitated in some way, and I was supposed to be her legal guardian, then I could have a right to be bringing and have standing in that court to be doing that. If I was a parent and my minor child, something happened to my minor child, I bring the case on behalf of my minor child, I could have standing in that case. But rarely, if you don't have a personal stake in it or a legal obligation to have a stake in the case, you do not have standing, and no matter whether you're in state or federal court, you can't be involved in bringing that case. Okay, they'll dismiss it. Okay, other types of jurisdiction, just to do this again, jurisdiction is, does the court have power to hear this case? And here's this very straightforward one. Subject matter jurisdiction is basically saying that the court has power over these types of specific subject cases. So we can go back to bankruptcy matters, for example. A bankruptcy court has jurisdiction over hearing bankruptcy cases. It would be a federal court. And family law, if somebody brought their divorce and they brought it to bankruptcy court because their business was going out of business at the same time, the bankruptcy court is going to say, we have no jurisdiction whatsoever over that subject matter. We don't have jurisdiction over those types of cases. So you bring your case where the court has subject matter jurisdiction, and that's spelled out typically by statute. Okay. In personam jurisdiction is another type of jurisdiction, and basically this is personal jurisdiction, what we say. The court has jurisdiction over that person. So if someone's a citizen in the state of Washington, the state courts have jurisdiction over that person. So in personam is a Latin term, but that's that. Then we have in rem jurisdiction, And I haven't found an easy way to remember this. REM in REM stands, the idea of it stands for jurisdiction over property. So you have land that's worth $100,000 up the North Woods, I don't know, in the Cascades, and there's somebody is suing you. The court has jurisdiction over that land. State court has jurisdiction over that land, depending again on the statute, but over the property. Quasi in rem jurisdiction is jurisdiction over quasi. Quasi means, in just lay person's terms, it's like kind of, sort of, it's almost property. In this case, what it means is personal property. So you don't have a piece of land that I can attach to get money from if you owe me money. You have a boat or something, or you have a motor home, and so what happens is I would seek to get a lien, L-I-E-N, a lien, have the court provide a lien that affects the title to your boat or motor home. And so that's personal property because it can be moved, and the court essentially has jurisdiction over it. They can attach jurisdiction over it if it was licensed here in Washington State, and it's here, it's present here in Washington State. They basically you wouldn't be able to sell your motorhome or your boat until the lien was satisfied, and I got my money back that way. Right. So quasi in rem jurisdiction is attachment. They attach a lien or a property interest against your property interest. Right. Then we have long arm. Long arm jurisdiction is, like it sounds, reaching with a long arm from your jurisdiction, your geographical area, to another geographical area and bringing somebody back. In a criminal case, you may be familiar with Martin Pang. He was involved a number of years ago in Seattle. He set a fire in a warehouse in the International District, I believe, and set a fire. And the purpose was to collect insurance money on the warehouse. His parents owned the warehouse. He was a bad guy, but a smart guy. He looked at the international jurisdiction and he fled the country, fled to Brazil. Well, what happened in the fire was at least 5 firefighters lost their lives trying to put this fire out. And since it was arson, it was set illegally, and it was set for fraud against the insurance company. He fled the state, and he was up for murder. And in this case, in Washington State, there's a death penalty. And I say he was a smart guy. He fled to Brazil. He's smart, even though he's so evil. He fled to Brazil, and Brazil does not have a death penalty. So the sense of long-arm jurisdiction, we have an agreement with Brazil to extradite or send people who have committed crimes back to Brazil. If Brazil said that there's somebody hiding in Seattle or Washington State or wherever in the United States, we have an agreement to send people back. They've agreed as well to send people back to jurisdictions that they're fleeing the law. Although in this case, since Brazil doesn't have a death penalty, Brazil said, we'll let you have him, but do you intend to apply the death penalty? And we said, of course. And they said, well, we won't let you have him then. And even though there's politics involved between the two countries and a significant issue, there's an agreement between the two countries. There's a fundamentally different view of what the jurisdictional requirement was. And the only way that Martin Pang was ever allowed to be let out of the prison in Brazil and sent back for trial in Washington State was when Washington State agreed that the maximum would be life in prison without parole, and that's what he ended up getting, and not the death penalty. So long-arm jurisdiction is trying to apply your law elsewhere with a long arm, stretching out with your law to try and get people to follow what your jurisdiction says. And internationally, it gets very complicated, as you can tell, with the politics of that. So, all right. Some other terms up here, things to think about in the jurisdiction context. Venue is basically, the idea of venue is the venue basically means place, and it's the place where it makes the most sense to have your trial. And so most often that is, if there's a car accident, it should be in that location. So even if it's a federal case that you've brought, and your accident was on I-5, it happened in Seattle, it makes sense for you to bring your case in a Western District of Washington. If it's involving two parties, one lives in Spokane and one's in Seattle, where did the accident happen? It happened still in Seattle. It makes sense to have the trial in the location where it happened. And so it should, as it says here, proper venue is most often geographically located where where the incident happened, because you have all the witnesses there, the evidence is there, all that is, it makes the most sense to have it. In criminal cases, it gets complicated because sometimes you don't get a fair trial on that case, and it's argued you wouldn't get a fair trial because it's been in the news, Martin Peng did this, 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 and this, and even without a trial, it'd be tough to get neutral jury members from this location here in Seattle. So it may be that the case might have been relocated. I don't know if it was at the time, but it might have been, you suggest that you move venue to Eastern Washington, the district in Eastern Washington, where you might be more likely to get a jury that would be less biased. Sometimes businesses are smart about this in advance. They put this in their contracts, and they basically have a forum selection clause, which basically says, if we have a dispute, we are going to use Washington state law. If we have a dispute, we're going to use Delaware law. Whatever it would be, they spell it out in advance, and that's often a smart way to go when you're doing these things. All right, the next several slides, if I could put it all into one slide, one page, here it is. And this document, I believe I have for you in course materials and links also. So if you want to look there, you'll see the whole process. This is a civil litigation process. So all of your ADR efforts have gone awry. You've not been able to resolve it through alternative dispute resolution of any means. You are at a point where you need to bring your case and file it in court. And so what's the process? So we're talking civil cases again now, not criminal cases. So we'll get to that in Chapter 8 on criminal law. But here's the civil litigation process. Okay. So you start with the pleadings. You file a complaint. So usually you go to the equivalent of whatever your county clerk is. You go with a copy of the complaint, one for the clerk, one for the opposing side, one for you. At least there's a minimum of 3 copies like that. And so what do? You have them. You pay a fee, and it's stamped by the county clerk. You also have a document called a summons, which basically means this party, depending on the jurisdiction, the defendant has either 20 or 30 days to appear or file an answer. So they have to respond to you, or they have to actually appear. And so you've paid your fee. All those are stamped on a date and time that you filed your complaint. And now the summons and the complaint have to go out to the defendant. So you have somebody called a process server who goes out to the defendant and hands them the summons and the complaint. And sometimes these people have to be very creative, because defendants who know a lawsuit is coming try to hide. They do all sorts of things. So process servers can call up and say, are you John Smith? And the person answering the phone says yes. And they said, John, you've won a flat panel screen TV. Will you be there this afternoon for us to drop it off? And John says, oh yeah, sure. How did I win this? So it's like, well, your name was drawn on something. They make up a story. And then the process server shows up at the door, knocks on the door. Are you John Smith? Yes, I'm John Smith. And then they hand them the summons and the complaint. And so what that basically means, now the process server has to go back and say, on this date, at this time, at this location, I served the summons and complaint to John Smith, who appeared to be a man of such and such age, such and such height and weight and all that. And you have a sworn affidavit. So the process server is saying this person knows that they've gotten the complaint and the summons. And the process server is basically attesting to that in a formal document that's provided back to the plaintiff and to the county clerk, right? So the defendant has some options now. The defendant has this complaint in his or her hands, and the defendant can crumple it up and throw it in the garbage and say, this is a bunch of junk, I'm not doing anything, which I don't recommend anybody ever do, because if you do, what happens is you're going to have a default judgment against you. The 20 or 30 days go past. The plaintiff shows up in court and provides the process server's affidavit that says that they served this material to the defendant on this time. The defendant is not in court by way of their attorney or the defendant themselves, and the judge says, ruling in favor of the plaintiff, everything in the complaint is deemed to be true. And then there's a whole process that the plaintiff has to now has a judgment and has to have the judgment exercised. It can be done by filing a lien against a person's property, all those types of things we've already talked about for jurisdiction, and so there's a judgment. So doing nothing is not a good option. Basically, it's probably a good idea, no matter what, if you ever do receive a complaint, to hire an attorney. Even if you think the complaint is meritless, spend a little bit of money now to have an attorney review your case, and talk to you about options from there and what you should do. Most often you're going to answer the complaint, and what you're going to do is admit, yes, my name is, and my address is, and then deny, deny, deny. All you do is I deny paragraphs 1 through whatever, 28 of the complaint. And it's very short. The answers are typically very short. Complaints are typically a longer document because they're trying to spell out all the things that the defendant did wrong. And the defendant is just going to admit typically just their name and address, that's about it, and then deny almost everything else in the complaint. And sometimes the defendant will make their own counterclaim and their own defenses. So they say, well, that might be true, I admit to this, but I'm making a claim against the plaintiff for this reason. Or I have a defense to the reason, the things that are being complained against me in the complaint. Okay? So defendant can, other than answering the complaint or doing nothing, which again I don't recommend, the defendant can file a cross complaint. In a cross complaint, it gets a little complicated, but it's like filing their own complaint. In response, they're saying, well, they might say, I'm filing my own complaint, and it's based on this. The plaintiff beat them to the punch to filing a complaint, and actually, now you're filing your own complaint in response, and you are the ones trying to take charge in this case instead of it being the other way around. Now, it gets complicated of the titles because now you are the cross complainant, and the other person is the cross defendant. And so, in the prior situation, that you were the defendant and the other person was the plaintiff. So now you've got two cases essentially going, and the court's got to make a decision as to how to proceed with these two complaints that are, or complaint and cross complaint that are going on. Sometimes you don't even answer the complaint at all, and you don't file your own complaint. You file what's called a demurrer, or a motion to dismiss. And we used to joke in law school and say this is called a so what motion. So you filed your case against me and you said I caused a car accident, but that was over 8 years ago. Well, the statute of limitations, the time in which you have to bring your case for a car accident case, is 3 years in Washington State. From the day of the accident to the day you file a lawsuit, you can't be longer than 3 years. And so you've waited 8 years to make your case, and I say, okay, I don't answer your complaint. I say it's without merit. I make a motion to dismiss because it's past the statute of limitations. Okay? So statute of limitations is a significant way that could be brought up. Could be that you make your so what motion, your motion to dismiss, or your demurrer on the basis of being improperly named. Yes, your name is Jan Jones, but there are lots of Jan Joneses, and you're the wrong one. And sometimes that could be you're wrongfully named, or it could be that it's improper jurisdiction too, is another alternative reason for demurrer. This case was brought in the wrong court. It might be that I could be a party in this case, but it needs to be brought in a different jurisdiction because it's not been properly brought. So you're either improperly named, it's an improperly located case, or statute of limitations. Lots of reasons why you can make a motion to dismiss. Okay? And in some cases, you don't even have a legal duty to the person. You're not responsible for them in this accident that happened. It might be they were a passenger, or you were a passenger somehow, and they're claiming your fault, and you had no legal duty to do something. You could also make a motion to dismiss based on that type of situation. Okay. So you haven't gotten to trial yet. The complaint's been filed, and together, the complaint and the answer, that's what we call the pleadings. Those two together. So in some cases, you might have what's called a motion to intervene or a motion for consolidation. A motion to intervene is done like this. Let's say a local franchise that is operated by a family, and it's the local franchise for McDonald's, and it's in Shoreline, let's say. And a family runs it, but they own the franchise, and so they get sued for some reason. Well, it matters to the big corporate McDonald's that they're involved in cases that involve their franchisees. So it may be very well that corporate McDonald's makes a motion to intervene. They want to be involved in the case as well. So they want to be named as a party, even though they weren't involved in whatever it was that happened on the premises of the Shoreline McDonald's. Okay? Motion for consolidation is to try to get all cases that are similar facts and similar defendants consolidated together as one. Typically, we call those class action cases today. And so you had Ford a number of years ago with the Ford Explorers. They were said to be designed, improperly designed, and so what happens is people would drive them and they would roll over and people would be injured in them. And so people across the country were filing all these lawsuits, and then it came time when there was a motion to consolidate them into a class action and file one case instead of having hundreds of cases, maybe even thousands of cases, in all these courts and tying up all the courts. So, in one sense, class actions make a lot of sense. They do enable parties to have where there are similar facts involved, similar plaintiffs, similar defendants. There's a whole statutory requirement as to what is required for a class action, but those cases get consolidated into one, and it saves court time and money and all that by consolidating them. There's a lot of criticism of class actions too, because it says the only people who get rich off of them are attorneys. Some people debate this, and they say that this is we should do away with class action cases. The attorneys often get the most of the settlement in these cases, and people who really are have been injured don't get their fair shake as if they were on their own case that was not part of the consolidation. And so you're not obligated to consolidate often. There are options that people do not consolidate to be part of that consolidation, but the motion for consolidation is to join all the cases essentially as one, and it's saving court time and it's more efficient is the in theory why they're done, right? So all the motions, think of a motion too as a piece of paper. Usually you can have oral motions in court, but typically they're a piece of paper is drafted and they're handed to through the court system. The judge gets this and asking the court to make a decision, and you want them to move in your direction. So the term motion is what you're talking about. Long before you ever get to court, and this is probably the most expensive, particularly in corporate litigation, discovery is what we're getting at here. The American system of justice and civil procedure enables businesses to conduct a discovery process that's very much like a fishing expedition. It's been argued, and because of that, litigation is very expensive to undertake. So you have a corporate dispute with a company, two corporations are fighting it out, and one corporation says they want all the documents that pertain to making whatever X widget, this product, for the last 10 years. And they want all the correspondence between the vice president of sales and marketing and whatever, who knows, or engineering department, because they think that something was done improperly. So they can request all these documents from people. And of course the other side can squawk about it, but and there are ways we'll get to this where they can fight it in court where they don't have to produce all that documentation. But the fact that you're asking this other side to go through all this work to gather all these documents and copy them and scan them or whatever is very tedious, very expensive, and most often leads to a very minuscule number of documents that really ultimately pertain to the end value of the case. So it's seen as an expensive waste, but also necessary to prove your case. What you're trying to do is discover everything you can. You have your own arguments about why you should win or why the other party should lose, and you need to have some evidence to prove your side. And so each side gets to ask each other for this information. And sometimes that is done in the form of depositions. Depositions are sworn oral testimony that are taken. Usually, the other side or your side calls a party to their office, to the lawyer's office. Lawyers from each side are present. The parties are present, typically. At least who's being deposed must be present. And they are asked questions about the case, and they are sworn to tell the truth, nothing but the truth. When they do this, there's a court reporter there that's typing every word down, the questions of the attorneys and the answers from the party. And then later on, if there is a trial, often what is said at depositions under oath is used when a witness on the stand and is not giving testimony that's consistent with what they have said previously. So it's used to discredit someone on the stand during trial. It was like, okay, you're saying this today, but you said this previously, while you were sworn under oath. So which is the truth? And so the credibility factor is significant. So depositions are a way of discovering the other side's you're providing evidence from the other side based on oral testimony, and it's sworn. Interrogatories, we used to abbreviate this as ROGs, are written sworn testimony, and basically you're asking questions of the other side. Were you speeding at the time of the accident? Have you ever been involved in another car accident before? Have you ever been involved in another lawsuit before? And so they're written testimony that is sworn, that's provided. You have admissions that are also written testimony that's sworn, and you may say, do you admit that you were under the influence of alcohol on the day of the accident, or do you admit that you've taken XYZ medicine or something on the day of the accident? And you admit or deny that you were, and it's sworn as to how you do this. Something that gets very expensive on the corporate level when you're doing these cases, and I've worked on them, is a request for production of documents. RFPs is what we would abbreviate them as. The other side asks for all these documents, and then you have to talk to the corporate people who are responsible for maintaining those documents, and that might be in 20 different cities or 10 different locations, wherever it is, that you make the request for all these documents. They provide them. They may just ask you to come to their city headquarters or branch office, and you or the attorneys involved in the case go through all the documents and find the ones that are relevant to what the request is. You designate them to be copied or scanned, and then you number them, and you provide the numbered copies to the opposing side, and you maintain a copy for yourself, and you can tell how that's going. It's going to be a very expensive matter to do all that, but you're entitled to that documentation. If this case involves somebody who claims that they have physical or mental injuries, the defendant certainly can ask for a physical exam, and not just by your doctor, but by their doctor. They can have a mental exam by their doctor. They're entitled to that because you're making accusations that they are responsible or liable for your injuries, physical and mental. Then you're entitled they're entitled to have their own experts take a look at you. When people don't play along well, they don't play like good kids do in the sandbox together, then we get to this thing called a motion to compel. And you're basically asking the court, if none of these things above are available, because a party is refusing to let somebody be deposed, for example, they say, well, I'm sorry, our vice president's not available, he's in France. Well, when will he be back from France? Well, he's there for, the next year or so is his job. He never comes back to the United States in the whole year? No. Well, we'll go to the embassy in Paris and we'll have a deposition there. How's that? And they say, no, well, he's actually sick now. So you could tell they're not complying. Then what you have to do is you ask the court to assist you, and you make a motion to compel. And this could be for the production of documents where they're not cooperating. It could be answers to interrogatories. It could be a deposition, you name it. And what you're doing is basically the court orders that the party who's not complying actually do it. Unless they believe that you're asking for too much, then the court might say no, we won't award grant the motion to compel in your favor. But if they do say that the party isn't cooperating, they usually make it, in the corporate world, they make it very expensive to continue that behavior. So they'll say, that's okay, you don't want to cooperate, then every day it's going to cost you $10,000 for every day you're not complying, and it'll add up. So that gets them to comply. It might be depositions, as I mentioned, too, but when you're not cooperating, that's what happens. So discovery is taking place, and then we still aren't at trial yet. We have a time period where you could basically have pretrial motions, and sometimes here what you want to do is get the case dismissed, and so how do you do that? You can basically do this. One of the ways is, and again, you're not going to go to trial if this happens. You have a motion for judgment on the pleadings. This is way long before even discovery ever took place. You have your complaint and the answer, and that's the pleadings, and then you go to the judge and make a motion for a judgment on the pleadings right there. Your Honor, we make a motion to dismiss this case because the accident happened 8 years ago. It's past the statute of limitations, and this person wants personal injury damages, dollar damages from me, and it's 8 years old. And the court says, based on the pleadings, both parties had agreed to when the date of the accident was, awarded on behalf of, and then the judge corrects the gavel. So that's long before discovery happens, long before anything else. It's just on the basis of the pleadings. The other way is, and again, if all the facts are true according to how they've been pleaded, then whoever is making the motion is going to win. Another way is what's called a motion for summary judgment, and most often this is after everything's gone through and you've done all the discovery, you have a good idea of where the other side's arguments are, where your side's arguments are, and basically what you're doing is you're saying, Your Honor, this is a legal decision that needs to be made here. There's nothing that a jury needs to decide. You can look and see the facts for themselves based on the pleadings and based on deposition testimony or a key document or series of documents or answers to interrogatories that have been provided. It's very clear that there's nothing that needs to be decided by a jury. So, Your Honor, we make a motion for summary judgment, and we want the judge just to decide on the basis of the law. And there's not a factual decision that a jury needs to make, and the judge can make a decision right then and there and say, motion for summary judgment granted on behalf of whoever's making the motion. If there is some question of fact, that's something that the jury would likely need to decide, even as one significant fact, the judge is going to deny the motion for summary judgment and say this has to be heard by a jury. Okay? So we still haven't gotten to trial. Notice, now we're at pretrial hearings and settlement conferences, and this is ultimately to try to get people to settle before you to get to trial. And why is this? Because in pretty much every jurisdiction in the United States of America you're going to see it's created by statute, and it requires that some type of a pretrial hearing or some type of pretrial conference with the judge and both attorneys from each side is required, and you're trying to, if possible, reach a settlement without going to trial so it doesn't take up the actual court trial time. Now, if the parties still don't agree to some sort of settlement at this last juncture, what the judge may do is say, look, both sides agree to the liability here. One party was clearly at fault. You understand you're at fault. What you're disputing really is the dollar value of the extent to which you're at fault. The plaintiffs say they're entitled to $10 million, and the defense says it's only $1 million. You can't come to an agreement on that. So we're going to limit the scope of the trial to just dollar damages and not talk about liability. And so that, again, frames a much shorter trial than you would have had otherwise if you're trying to prove every element of the case. And so this is required, like I said, in most every jurisdiction where you sit down with a judge. Often in chambers, the attorneys on each side will sit down with the judge and talk out the case to try to, at the very least, limit the scope of what the trial is going to look like. Sometimes that doesn't happen either, and then we're looking at trial. And in trial, there's a whole process. We have to go select a jury now, and so this jury process that's involved is called voir dire, and basically voir dire in French means to speak the truth. And so this is what we're trying to do, is ask questions of potential jury members to eliminate any ones that are biased. So you would get your notice in the mail that says, you are called to be a jury member in this case, or a potential jury member. You show up on the day and time. If you don't and you throw that away, it's a criminal offense. You need to be aware of that. You're going to be asked a lot of questions pertinent to the type of case to see if that's involved here without naming names, and to see whether you have any bias or not. And so usually this process is conducted by judges. I've been called as a jury member, and actually was conducted with a judge overseeing it, but it was conducted by the attorneys themselves. The judge can challenge the person who is being questioned and let them be out of jury duty based on cause. It's called challenge for cause, and the judge can do this. And and the judge, it's an unlimited number that the judge may do. Peremptory challenges are done by the parties' attorneys, essentially, where they say, we excuse this person from being a juror in the case because they feel you're biased. They don't have to. Pardon me. I did something wrong. Hold on a second here. Sorry, you guys. It escaped. I went a little bit faster than I wanted to go here. Let me go back up on here. I just was on the wrong page. So here we go. I'm way ahead of myself. Let me go back. Apologize for. Here we go. the peremptory challenge, the challenges for cause is unlimited. The judge can eliminate as many juror members, potential juror members, as the judge wants to. Peremptory challenges may be done for any reason at all. The attorney for one side doesn't like the way somebody looks or doesn't like the way they answer a question, they don't have to have any reason. But if it turns out that, I mean, they can't excuse people because of their race or their gender, any discriminatory way, and the only way that can be established typically is by showing a pattern of who gets excluded. Suddenly you have only white males that are left on the jury. That might be that your pool started out with percentage-wise many, many more white males than anybody else, and that can explain it. But if only women or only people of color are being excluded by one party, the other side can object to this, and with good reason they have a right to do that. Basically trying to eliminate bias and having people be neutral who are going to sit on the jury. Okay, so the actual trial starting, I'll put all this up here now. I'm just going too fast. The actual trial is going, and each side gets to present their opening statement. Opening statements are not to be considered to be facts. They are each party's interpretation of the facts and the things that they want to highlight the jury's attention, focus on. The plaintiff brings their case first, and what that means is they bring all the witnesses that they have on a list that they've provided to the defendants in advance. They call all these people up in order and ask questions and provide all sorts of documentary evidence and slides and whatever they need to show to provide proof of their case. And when they are questioned by the plaintiff's attorneys, the plaintiff's attorney sits down, and then the defense attorney gets to cross-examine and ask questions. The defense attorney sits down, the plaintiff gets to ask more questions, redirect examinations, they call that. The plaintiff's attorney sits down, the defendant's attorney gets up again and may ask some other questions, and we go back and forth like that. And at the end of all the plaintiff's cases, then the defense gets to make at the end of all the plaintiff's witnesses and testimony that's given, then the defendant gets to do the same thing, and we are in reverse order now. Now the defendant gets to ask questions of their witnesses first and call their witnesses according to a list that they've provided the plaintiffs in advance, and the plaintiff's attorney gets to cross-examine and ask questions as well, and you go back and forth. At the end, there might be some rebuttal from either side. You might have some evidence that, or a witness that comes up to rebut anything that's been done before on the other side. Rejoinder. Both of these opportunities to reshape the view for the jury's sake of what evidence has been provided in the case thus far. Then we get to the point. This is actually from a criminal case. Any of you have seen this with Gregory Peck. It's escaping my mind, even the name of the movie right now. I apologize. But a criminal case, a very famous Gregory Peck, I think, won an Oscar for this. So disregard the picture in a sense, but not. Trial takes place, and at the end of trial, there's a closing argument that's made by each side. Again, not to be considered facts of the case, but each side gets to, again, highlight what they believe has happened and refresh the jury's memory of what's required to prove the case against their party or in favor of their party, and then the jury is instructed. Now remember, from the very beginning of this, I said, who's the expert in the law? The judge is the expert in the law of all the people who sit in the courtroom. And the judge, jury instructions, in most jurisdictions, there's a formal stated choice of what the jury instructions are supposed to be, and then you can choose from them, and both parties agree to what they're going to be in advance. Sometimes they're drafted entirely by the parties themselves, and then they're hammered out as to what those should be. But the bottom line is the instructions on the law are presented to the jury to remind the jury, in a civil case, in a criminal case too, what the focus of the jury needs to be. This is the law in the jurisdiction. If you find X or Y or Z to be true, then you need to rule this way. And the judge will tell the jury this is what they need to do. And so instructions are made, and then the jury is supposed to determine what the facts are, and then the application of the facts to what the law requirement is based on what the judge has said is what's significant. The jury goes in a room, they deliberate, they talk about it for a while, they come back with a decision, and there's an entry of the judgment, which is called the verdict. And sometimes one side may say, Your Honor, the judgment has happened, and this is inconsistent with the law in this jurisdiction, so we make a motion for a judgment NOV. NOV is Latin. Now you look it up in your textbook. It's non obstante veredicto, which means notwithstanding the verdict. So even though the verdict has ruled against us, Your Honor, that based on the law in this case, as it's gone forward in our trial, it's inconsistent with the law in this jurisdiction, and so we ask for you to overturn the jury's decision. And the judge may do that. Judges do that. It happens. If the jury misinterpreted the law somehow, and the judge believes the jury misinterpreted the law or was biased somehow in the process, it's not consistent with legal principles, the judge may overturn the jury's deliberation and grant the motion for judgment NOV. It may be that the damages awarded are extraordinary, and the party on the defense is saying we want to reduce the damages. In that case, they make a motion for an order remittiture, and so reduce the damages, Your Honor. This might be true that there's damages that have happened here, but $12 million is excessive, and no other case has been like it, and so you ask the judge to reduce that. So in either of those cases, the verdict, judgment NOV, or order remittiture, all those can be appealed. And as you know, when we've talked about appeal already, typically you file your appeal between 20 or 30 days, whatever the jurisdiction requires. If you miss it by a day, you're out of luck. And that's your trial, and that's the process. So I'll leave it at that, and we'll move on into Chapter 6 in our next go-around. All right? And that's it for today.